Hi, in this lesson we're going to be talking about deeds. And you might remember way back when we talked about the parties to a deed, the grantor and the grantee. The actual active verb with deeds is the word grant. Deeds are granted. So the party giving the deed is the grantor, the party receiving the deed is the grantee. And there are four types of deeds that we're going to be talking about. The warranty deed, the special warranty deed, the bargain and sale deed, and the quitclaim deed. And what I want you to realize is that the basic difference between these types of deeds is in the amount of warranties that the grantor gives to the grantee. Typically, deeds are given when a property is sold. So the seller, in transferring the property to the buyer, is going to buy the buyer title insurance. And we'll talk about title insurance in another session. But let's presume for the time being that there is no such thing as title insurance. So what happens, what kind of protection do I, the seller, give you, the buyer, when I transfer title to you? What kind of protection do I give you relative to the fact that there are no other liens or encumbrances on the title that I haven't disclosed to you, that there's no undiscovered heirs, that nobody else has an interest in the property that I'm transferring to you, and so on. So the basic difference in these types of deeds is in the amount of warranty that the seller, the grantor, gives to the buyer, the grantee. So let's talk first of all about what a warranty is. A warranty, as you're probably familiar with already, is some sort of promise of protection against defects. When we buy a car, we get a warranty. When we buy an appliance, we get a warranty. So a warranty is a promise of protection against certain defects. Now, the warranties in the deed have nothing to do with the physical condition of the property. So the warranties in a deed do not relate to the roof or the plumbing or any other condition relating to the property. What the warranties in the deed relate to, again, are title defects. And let's explore these deeds from the top down. So the first one is called the warranty deed. And a warranty deed, all right, let's talk about the party. So here we have the grantor, D&A Carapellucci, H&W, meaning husband and wife, do hereby convey to Jim Chapman, a married man, the following described property. And here's the legal description of the property in the deed. Let's say it's lot 27 of the Hogan subdivision. Well, even though this deed is called a warranty deed up at the top, there's a very important paragraph that you would read in this deed. And here's what it says. I've highlighted it for you and blown it up. It says, "And the grantors warrant the title against all persons whomsoever." And the grantors warrant the title against all persons whomsoever. So what that is saying is that I, the grantor, in giving you this deed, you being the grantee, that I, as the grantor, promising to protect you against any and all defects in the title. Not only things that I had something to do with, but something or things that somebody in the past had something to do with. Because I'm promising to protect you against any claims on the title. So if some undiscovered heir from 3 owners ago came up and said that they own the property after I transferred ownership to you, I would have to protect you against that particular undiscovered heir. Now, how good is that warranty that I might give you? How good is any warranty that you get? Well, it's only as good as the maker or the giver of the warranty. For example, how valid or valuable is a warranty on a 1955 Studebaker? Now, for those of you that don't know what a Studebaker is, it's a car. It was a car that was built in the 40s and 50s and so on. Well, Studebaker is out of business. So even though you have a lifetime warranty on the Studebaker, that warranty is no good because of the fact the company's out of business. So how good is the warranty that I might give to you? Well, it's only as good as I am financially capable of protecting you. So if I'm broke, that warranty doesn't do you any good. And that's why, as we'll see in another lesson, that title insurance becomes so important. But again, right now, let's presume there's no such thing as title insurance. But if there was, and this claim came up from this undiscovered heir, and I was broke, you would be able to have recourse in all likelihood to the title insurance policy. So that's the warranty deed, basically promising you protection, promising the grantee protection against any and all claims that might come up against the title. So warranty deeds then give the greatest protection for the grantee. And interestingly enough, they are by far the most commonly used type of deed in a real estate transaction. Now, the next deed that we want to talk about is called the special warranty deed. By the way, the warranty deed is also called a general warranty deed. And wouldn't you rather have this special thing rather than a general thing? Well, don't be deceived, because a special warranty deed does not have as good a warranty as the general warranty deed or just warranty deed. So a special warranty deed, here we are, Jim and Esther Hogan are the grantors, do hereby convey to George Jensen, a married man in severalty in his sole and separate right, the following described property. And here's what's called a government survey legal description, the northwest quarter of the southwest quarter of Section 19, Township 14 South, Range 14 east of the GNSR B&M, Arizona. Whew, that's a mouthful. All right. Well, that's a government survey legal description that we discuss in another session, but that property happens to have 40 acres in it. But most importantly, there's a provision down here that deals with the warranty. And it states, and the grantor hereby binds itself and its successors to warrant and defend the title against all its acts and none other. So what is that saying? What it's saying is the grantor promises to protect the grantee against things that the grantor did, but nobody else. So there's a lessening then of the protection that the grantor gives to the grantee as compared to a warranty deed. So this special warranty deed then protects only against the grantor's actions. Now the next one is called the bargain and sale deed. And in this deed, like in the others, we have a grantor. Here's Joe Mama, good friend of mine, conveying to Chester Drawers, another good friend of mine, the following described property, and it's lot 14 in Tooth Acre subdivision. You ever have a tooth acre? Well, that's a lot and block type description. But here's the key on a bargain and sale deed. There's no statement of warranty in a bargain and sale deed. In the warranty deed and the special warranty deed, we had written statements of warranty. Here there is no written statement, no stated warranty, no expressed warranty. However, under the law, there is an implied warranty, and that implied warranty is that the grantor has the legal authority to convey the title. But take a look at your notes here in your course material. In a bargain and sale deed, there's an implied warranty that the grantor has legal authority to transfer title. Well, when would a grantor really not own a property but have legal authority to convey it? Well, the answer is typically in three situations. The first one there, guardian's deed. Well, let's say we had somebody who was incompetent, and their legal guardian had control over their property. That legal guardian would have never owned the property, doesn't own the property, but has the authority to convey. They would probably use a bargain and sale deed to do that. So the warranty that they're offering is that I have legal authority to convey title, but no other warranties. Also, an executor's deed where a property is sold or transferred out of probate, or a deed given in a foreclosure, such as a sheriff's deed, a trustee's deed, or a treasurer's deed. The sheriff in a judicial foreclosure doesn't own the property, but he has legal authority to transfer ownership, and foreclosure deeds typically take the form of a bargain and sale deed with no stated warranty whatsoever. So again, no express warranty. There's an implied right to convey that they have this authority to transfer. And these are typically these third-party deeds, guardian's deeds, executor's deeds, foreclosure deeds of various kinds are typically bargain and sale deeds. Now the last one we want to talk about is the quitclaim deed. Not quick claim, but quitclaim. Because in a quitclaim deed, the grantor, howdy doody here, quits claim, releases any interest that they have to the grantee, Buffalo Bob here, on this following described property. And you'll notice there's no statement whatsoever of any warranty, and there's nothing implied. So what I want you to remember about quitclaim deeds is that there are no warranties whatsoever in a quitclaim deed. So no warranty. So if you see a question on the exam that says which deed has the lowest or no warranties, it's a quitclaim deed. Which deed then gives the grantee the least protection? It's a quitclaim deed. Which deed has the lowest or least liability for the seller or the grantor? That too is the quitclaim deed. Now usually these are used to clear up title defects. Also in a divorce situation. The husband and wife are divorcing. One is going to give the property to the other. So typically they will use a quitclaim deed. Or someone claims some interest in a property and they wind up giving it up, maybe because you compensate them, maybe because they realize they don't have any interest. They would use a quitclaim deed. No warranties whatsoever. In fact, I don't even have to have ownership in a property of any kind to give you a quitclaim deed. For example, I could give you a quitclaim deed on the Brooklyn Bridge. I grew up close to the Brooklyn Bridge, and that deed itself would be valid. However, if I took money, if I led you to believe that I owned that property and gave you a quitclaim deed, the deed in theory would be valid because I'm giving up whatever interest I have, if any, but because I defrauded you, I would have liability under criminal statutes, actually. So there are 4 different types of deeds, remember them, from highest to lowest relative to warranties. The warranty, also called general warranty deed, the special warranty deed, the bargain and sale deed, and finally the quitclaim deed. Now some other types of conveyances that you should be aware of and are also called deeds or forms of deeds. There's 3 of them. The first one is called a patent or a land patent. A patent is the document that's used when property comes out of government hands into private ownership. So here in Arizona, since most of the property here was owned by the government at one time, if you go back in the chain of title, the last document or the earliest document you will find is what's called the patent. And in a lot of circumstances, the patent, whether it was issued by the state or the federal government, reserves here in Arizona, not in all cases, but in many cases, reserves the mineral rights and the oil rights. So going back in the chain of title to the earliest document, in most instances here in Arizona, you'll find a land patent. And by the way, this term has nothing to do with inventions. The term patent deals with the deed or the document transferring ownership out of government hands into private ownership. Another document you should be aware of is called the beneficiary deed. Now this is really an estate planning tool. And let's take a look at your notes relating to a beneficiary's deed. It says here a deed that specifies who will receive real estate when the grantor dies. A beneficiary deed is recorded by the grantor while the grantor is alive and can be rescinded or changed at any time before the grantor's death. But at the moment of the grantor's death, what happens is that ownership of that property transfers to the person named in the beneficiary deed. Now, a beneficiary deed only takes effect as of the grantor's death. So prior to the grantor's death, the grantor can change it, can rescind it if he or she chooses. But once that person dies, once the grantor dies, then ownership of that property transfers to that beneficiary, to that person named in that beneficiary deed without probate. So it's a way of avoiding probate. So the transfer under the beneficiary deed also, as your notes indicate, will supersede the grantor's will. So if in the grantor's will it says, well, this property goes to so-and-so over here, but in the beneficiary deed it specifies it goes to another person, then the beneficiary deed takes that property outside the jurisdiction of the grantor's will, of the deceased person's will. Now, one of the other things you should be aware of relating to a beneficiary deed is that if the grantor was in the process of selling the property, there was a contract to sell the property to a buyer, and then the grantor passed away, the beneficiary deed would have effect, but the beneficiary then, the person who acquired the property after the grantor's death, would have to abide by the terms and conditions of the purchase contract and complete that sale, because the terms of the contract are not terminated by the grantor's death. Now, another type of conveyance that you need to be aware of is a disclaimer deed. And let's say we have two spouses, one of whom wants to acquire property in his or her sole and separate right. In that circumstance, the title insurance companies are going to require that the spouse not acquiring the property sign a disclaimer, giving up, saying that they don't have any interest in the property that the other spouse is acquiring. That way they feel much more certain that the person acquiring the property would be able to convey that property down the road without having any community property issue clouding that particular transfer. So that's a disclaimer deed. It's actually given or executed prior to the other spouse acquiring the property.